All right, this is Copyright 2 Part 2, and we are in the textbook at pages 84 to 92 and 98 to 104. So what do we have there? We're still where we left off in the previous capsule, talking about this first right that is granted to the copyright holder, and that is the right to produce or reproduce the work. And again, as we discussed in the previous capsule, what does it mean to reproduce the work, or actually to violate any of these rights? Well, we have this trigger issue that we discussed before of substantiality, and so these rights are only reserved to the copyright holder when they concern the work or any substantial part thereof. And so we have two cases in this section that help us understand what it means to reproduce a work or a substantial part thereof. So what do we have? We have the Cenar case from 2013, right? Which is a pretty well-known case, though it's very recent. If you read my research, you know that I'm particularly interested in what it's meant for personal injury victims. And so the case has redefined a bunch of things in different areas of the law. One of those is how you quantify and compensate damages, right? And another is, in copyright, what counts as copying, right? So there's this kind of liability issue of whether or not you're owed money because someone violated your rights. And then there's this issue of how you quantify damages. And here we're concerned mostly with the first, right? So what do we have in Cenar? We have Mr. Claude Robinson, who was an author of children's books, and basically wrote this book called Robinson Curiosity, that was basically new enough to constitute copyrightable work, right? And then Mr. Robinson registered that work with the Copyright Office, right? As you'll recall from last week, registration is helpful to use as evidence of the existence of a right under the copyright regime, but it is not mandatory, right? So you do not have to register your right under the copyright regime. And so Mr. Robinson essentially goes to a large corporation to turn his book into a television show, right? And he engages in very extensive negotiations with specific people at Cenar and some, associated corporations. And over a 2-year period, they come up with pretty extensive, detail as to how they could turn this into a television show. They produce storyboards and all that, right? Then they essentially, don't follow up on the project. And a couple years later, Mr. Robinson is at home and he sees on the television essentially that they stole his stuff, right? And it's devastating to him because it's his most significant work, and it's one that he's invested his entire life in. And what's even more tragic, if you look at the news, is that between that period in the 1990s and 2013, right, so 23 years later, when the Supreme Court decided the case, Mr. Robinson was stuck in the court system, spent over $1 million in legal fees just to get compensation. And that brings us back to what copyright is all about. Copyright is about people being able to turn their original ideas into works without being afraid that someone's going to steal them. And by doing that, is going to steal, the revenue source for their entire career. And so what we're told is that, and it goes up to the Supreme Court, right? So there's all the work that goes on at the trial court level. The judge in the Superior Court in Quebec hears the entire evidence for 83 days in this case. renders a decision, and then on appeal, right, you don't have a right to start over, you just have a right to see if a mistake was made, and generally it has to be a big mistake, and it has to be a mistake on the law, right? The law is reviewed on a standard of correctness, generally speaking, which is less deferential, and any other error is reviewed on a standard of reasonableness, and that standard is much more deferential, so it has to be a very big mistake for the appellate court to do something. It goes up to the Court of Appeal and then to the Supreme Court. The Supreme Court tells us, right, that they essentially, the trial judge heard the case for 83 days, heard all the evidence, compared the new version and the old version, and decided ultimately that the company had infringed Mr. Robinson's copyright and awarded compensation for that. The compensation issue, again, is not really part of the section of the case that you're given. So, where does the court start in its analysis of seeing whether the trial judge did something wrong or not? The court, again, we've repeated this over and over again because the courts do, right? The court starts with what the underlying policy objective of the Copyright Act is, and that is, again, to strike a balance between the public interest in the dissemination of work, right? The access of people to artistic or literary works, and the public interest in ensuring the creators get a just compensation for their work, which also incentivizes them to produce these works in the first place. The court, basically reviews all the cases that we've seen so far. So in that regard, it's a pretty good review. The court cites the CCH case, right, which we discussed last week. I called it the Law Society of Upper Canada case, which basically says, right, both that ideas, again, are not protected by the copyright regime, only the resulting works are, and that an original work, right, that's determined based on the way it was fixed onto a medium, right? So it's not the ideas that have to be original, it's a resulting work. And on top of that, we learned that the approach, right, can take into account how much work went into creating the medium, but that's not enough, right? You'll recall that I call the standard original enough, right? So it has to be original, but it doesn't have to be groundbreaking, right? And the work that was put into fixating the work is relevant, but not determinative. Instead, we look broadly at both of these issues to decide if the work is original or not, which triggers the protection of copyright, right? Because copyrightable works have to be original. So, court says, what is a substantial part of the work? Because what happened was, they were smart. Apparently, when they decided to copy the thing, they contacted their lawyers and asked what they should do, and they made it different enough so that under the standard that they thought would apply, it wouldn't be copying, right? So they kept, the main characteristic of the main character, but they kind of, diluted it a bit. They changed, I think the people into animals or the other way around, and so forth. But the setting was, on an island. So lots of things were similar, but enough things were different so that they felt that it couldn't constitute copying. And on the appeal, right, and probably also before the trial judge, that was the only issue that was relevant, right? So they didn't disagree, right, that they had met with Mr. Robinson for years, that they had contemplated that perhaps they would, produce a television show based on his work. They didn't contest that. They didn't contest that their stuff was similar. The only thing they said was, well, the copyright regime does not apply because it's not similar enough to be a violation of Mr. Robinson's copyright in his work. So it's a copy that's not really a copy, right? It's different enough not to violate his rights. And of course, what does the court do? The court does what it always does. It goes to experts, which are the main reason our judicial system is so expensive. Because the court cannot know what it means to download a document. The court cannot cannot know how cars stop, anything that's really the foundation of any civil case, right? The court cannot know on its own, and so it needs an expert, right? And here the court, trial judge, in the first instance, heard a bunch of experts, and the experts analyzed what was similar, what was different, and they're experts in comparing stuff, right? In the generation of meaning, essentially, and how these, specific things that are similar are enough for the viewer, for the person that analyzes it, because in this case the viewer would be a child, for the person that analyzes it to form an opinion or to feel that things are similar or not. Any expert said, well, it is similar enough. And we get back, the court gets back to this approach that we didn't discuss last week, but that was cited in one of the cases, which they call abstraction, filtration, and comparison. And this approach is not relevant because it doesn't apply. It's an approach from other jurisdictions that people, mostly people who violate copyright, have tried to import into Canada because it favors them, right? Because it makes copying much harder to prove. Because what you essentially do is you take the elements that are similar, and then you take away all the stuff, right, that is in the public domain. It's too general, right? So here we take away an island because that's not specific enough. And then generally there's so little left that the comparison doesn't, help us conclude that the copyright was infringed. And again, the court says, well, this approach does not apply. And that's probably what Cenar thought would work in the first place, right? They made some stuff different, and they made the calculation that once this approach was applied, there wouldn't be anything left, right? The stuff that they copied was too general, and there was enough stuff that was not similar, so that the approach would lead to conclusion that the standard, that the copyright protection of Mr. Robinson is not triggered. The court says, well, that approach does not apply in Canada. Instead, what approach do we use? Well, the answer is basically common sense. Whether you call it a holistic approach, you call it a cumulative approach, basically, you kind of look at the things and come to a reasoned conclusion based on all the evidence as to whether it's similar enough, right? Or if it's dissimilar enough, and therefore is original work that is copyrightable in itself, the second version, and therefore is not copying, right? And the court says, well, the trial judge understood that and did it right. Trial judge, did not take into account the stuff that was general enough. Because you'll recall, right, from the last portion of this lecture that I try to make the distinction as best I could between what's an idea and what is a similarity that engages the copyright regime. So you'll recall this, general rule that we've probably repeated 20 times already, that ideas are not protected by the regime, only works are. But as we said, that doesn't mean that you have to copy, for example, a book verbatim. If you steal the main character, right, then you engage the copyright regime, because that's not copying an underlying idea, it's copying a substantial part of the work, and that engages the copyright regime under this, right? It's a reproduction, essentially, right? And the trigger issue of substantiality is met, right? So it's a reproduction that reproduces the work or a substantial part thereof, right? And the court says, and therefore, some things that are general enough to be ideas, right, that are in the public domain, right, so aren't part of either what you're copying or what you're making, because they're too general, are not relevant. And the trial judge properly ignored them. Like the fact that they're on a beach, the fact that they're on an island. These are general things, right? Like driving down a highway. Even if I write a book that's about someone driving down a highway, that's too general. I can't prevent people in the future from copying my book on the basis that my book's about someone driving down the highway, and therefore no one can do that again, right? because that would be too restrictive and would tip the balance too far into the rights of the copyright holder to the detriment of the public, right? Because that would be good for me because I could prevent a lot of people from doing a lot of things. I could charge rent for that. But of course, the converse effect of that, that no one could write a book about someone driving down a highway without paying me. And that would be both unfair and against the public interest that underlies the regime. The court says these general things, as applied in Robinson, were properly ignored by the trial judge. The trial judge instead focused on things that are similar, that are more of the thrust of the narrative and are not general enough. Like the main characteristics of the character, the fact that, they're animals, they're a bunch of characters living together on the island and all that. And the graphic appearance of the characters and so forth. And the court says these things are not abstract ideas, right? Which again are not protected by the regime. But even though the Mr. Robinson's work was not copied exactly, was not copied verbatim, they copied a substantial part thereof. And that violates his rights because he has the exclusive right to the reproduction of the work or a substantial part thereof. And the court says also that the outlook that should be used to look at these issues doesn't fall into a specific category. The only thing the court says is it doesn't make sense to look at it from the consumer of the show, because that would mean a 5-year-old, and the court doesn't think that that makes a lot of sense. The court says to assess the similarity, sometimes you'll need an expert, right? Because perhaps, the example they give is classical music. Someone might feel like things are similar, but you need someone who really knows about this stuff to evaluate what aspects of it can be compared to assess the similarity and therefore come to a conclusion. Sometimes, however, a lay person, a normal person that is not an expert, will suffice in assessing the similarity. And that falls into, again, this approach of the court, which can essentially be phrased as common sense. The court says there's no hard and fast rules. We just kind of look at the thing, used our judgment in light of all the relevant circumstances. So in that section, we also move on, right? So that was at pages 84 to 92 of the textbook. And then we get to the second right that is protected by the copyright regime, and that is the right to performance in public. And you will recall that I emphasized regarding this that it is a compound phrase. So it's performance in public. You need these two things. Performance is fine, but performance in public is not. And again, we also apply this trigger issue. So the copyright holder only has the exclusive right to performance in public of the work or a substantial part thereof. And the case that we are given is a case from the Exchequer Court back in the days when the federal court did not exist. And it is we'll call it the Admiral case, right? And essentially this is about a football game that is broadcast, right? And the way it works now is the broadcast can be simultaneous, right? So someone is at the actual game and they see it live. Well, someone can watch it at home exactly at the same time, and that's live. It goes over through satellite, and then people receive it and watch it live. Well, then you'll understand, of course, this is just a general performance in public enabled by technology, right? Back in the days, you might have to fill a stadium. Today, you can get the same thing from broadcasting something live, right? Especially with the pandemic, you can't really be there in person. So that is a way to broadcast something live. And even though you're using technology, right, the general concept is the same. People are watching it live and on their own in a public setting, right? So the event is public, but the specific place where people watch it is not. And that's similar to people watching it in a stadium in a public setting. And so the court basically asks, what it means basically to watch it live. Because back then, live television did not exist, and so you had to actually record the thing and then physically send it somewhere, and then it would eventually be retransmitted in someone's living room, right? And the contract that is relevant in that case, right, says essentially, to make things simple, that they can the company that is broadcasting it can broadcast it live, but not afterwards. And so they cannot retransmit it afterwards for someone to watch it after. They can only watch it live. And so the issue here is whether, right, if it gets to someone's living room late, but once, right, not afterwards, not multiple times, it's just late, so it's not really live because technology didn't allow it back then. So it's not really live, but it is basically just once, as it would be if the person were watching it in a stadium. That's the first issue. The second issue is the company had this bright idea of basically playing it over and over again in their store, right? It's kind of a different setting. So the court has to look at what this means, right? And whether these two things are performances in public, right? And you'll recall that the copyright holder in that case did not allow the company to do indiscriminate performance in public. It was only live performance. And so if the company, does a subsequent performance in public, then it's not within the contract, and therefore it violates the right of the copyright holder. This gets us back to assignment, right? The person who has the copyright really only allowed the company to do one thing, because they have these three rights, and they can assign any or part of either or all of them. And in that case, they did not assign the right to subsequent performance in public, and therefore that would violate their right. They've only assigned one right. And the court says, perhaps unsurprisingly, in a similar way as the approach we adopted in Cenar, right, the court says, well, it is a very fact-intensive approach. And again, there are no hard and fast rules, but you kind of have to use your common sense and compare various settings to see what is public and what is not, right? And at the beginning, the very simple concept is this dichotomy, right? We know what in public means. A park is public, a stadium is public, a mall is probably public, our living room is not, right? Our bedroom is not. And then you have to see whether the specific situation of the case is more similar to one or the other, and then draw a conclusion as to whether it engages the protection for performance in public. And so what does the court say, right? The court says the games were broadcast afterwards, right? So even though the games were not broadcast live, right, they kind of were. The only reason they were broadcast later on was because the live transmission did not exist technologically back then. The court nonetheless says that this constitutes a subsequent performance, right? And therefore, the performance that counts is essentially that performance. And the court makes a bunch of comparisons with other cases that are useful because they provide their own specific sets of factual circumstances. So for example, the court cites a situation where something was broadcasted in a hotel, right? And what we're told is if it's for the patrons of the hotel, for the people who live there, then that's more similar to my living room, and therefore that would not be in public. But then if you invite people in, especially if they pay, right? Usually the reason you'd invite people you don't know somewhere, right? That's kind of not that fun, is because they're paying you. So usually, right, even though that's not dispositive, getting paid is an indication that it's a public event, because that's the reason you'd invite strangers somewhere. And if you start inviting, strangers into the hotel, especially if they pay for that, then it starts to have a public nature, right? And the court says, right, that even though, right, the specific transmission of the game may be a performance in violation of the copyright holder's right. That doesn't really matter because, as we said, right, it has to be compounded. It has to be a performance in public. And in that case, right, as we said, people are watching it, regardless of when, they're watching it in their living room, right? And if they're doing that, they're not in public. And the lawyers on the side of the company, right, try to say, well, if you're watching it at home, but then everyone's watching it at once, that makes it public, because even though they're all alone, right, there's a bunch of them alone at the same time. The court says, no, it doesn't work that way, right? These are individual events, and these are people that are not participating in public events, and so it's not a performance in public, right? And that's a situation that arises very often under intellectual property law, and especially under copyright law, right? Because if I buy a song, for instance, right, I have bought essentially, right, we'll make things simple, you don't actually own the song now, you own the license to the song, so you own a right to listen to it, right? If you own the song, you could do different things with it, and then the company doesn't want you to do that, right? So you buy a song, you have a license to use it, right? But you're the one who bought it, right? So you have acquired the right to reproduce the song, right? And you've acquired that right from the copyright holder, what would otherwise be a violation of their right, but no longer is because you paid them money for it, right? And so they consented to you using it, and the reason they consented is because they got money. But you did that. So if you start playing this song to your family, then your family hasn't paid for it, so you're in violation of the copyright because they don't have a right to listen to it. You do, right? And then that would be very clumsy and inconvenient, right? It would mean you can't record your television to watch it later. It would mean that you can't play a song in your own house, and that doesn't make sense. Not only is it, extremely complicated to apply and clogs the court system, it also upsets against this balance, right? And it gives too much to the copyright holders and too little to the right of the public to use the songs, right? Including when they've bought them. And so the court says, even though watching it in your living room, watching the football game in your living room is a performance, it is not a performance in public, and therefore it doesn't count. And the court gives some other examples, right? They give the example of a factory where something was played. Well, again, if there's no public there, it's only people working there, even though it's a commercial setting, right, which is usually where you have public events in a commercial setting versus a private home setting. Well, in that case, it's only the people working there, there's no public, there's no money involved. And so even though it's a factory, it's more of a private setting, and so the regime would not apply. And the court says, basically, again, that in the household, even though it might be a performance, it is not a performance in public. And the court also gets back, right, to this underlying issues of what is the purpose of the regime. So we talked about this balance before, right? There's also this idea that the goal of the regime, again, is to ensure the just compensation of the copyright owner, right? And if someone is playing your song at home, it doesn't really upset your ability to sell it. If someone starts making copies of it and selling them to people and they make money where you otherwise would be the one making money, then you can understand, in that case, that they upset your economic expectation to have your commercial monopoly, and therefore your universal right to be the only person who can reproduce the work. And the court says, well, watching it at home a day later in your living room doesn't upset it because it's not a commercial context, it's a private setting. And it doesn't really prevent the copyright holder from making money. In fact, in that situation, the people who broadcasted the game already were paid for distributing it, right? It's only the distribution happened later on. They were already compensated for that, so there wasn't a further commercial interest that was involved. And then the court looks at the second situation, right? Because you'll recall the company did two things. The company, one, broadcasted it in people's living room later on, and two, the company broadcasted it in their store. And of course, a store is a public setting. Anyone can go in And as we said, it's commercial. Again, it's not dispositive, but it's a good indication of what distinguishes a public setting from a private setting. And of course, a store that is operated for members of the public and for the store owner to make money, that is a commercial setting and therefore a performance in public. And so when the company broadcasted the football game again in their store, right, that was a performance, and it was in public because the public had access to the store.